let me be the first to welcome you to our webinar, Why Are We Incarcerating Domestic Violence Survivors? My name is Alexandra Bailey. I'm the Senior Campaign Strategist at the Sentencing Project. As I'm sure many of you know, October is Domestic Violence Awareness Month. And I can think for this conversation for a multitude of reasons. I think this is really a time for us to reflect on how the growth of mass incarceration drives the criminalization of survivors of domestic violence and abuse. But I think we will have a great conversation about the national proliferation of domestic violence survivor justice acts. Just a few housekeeping notes. I want to offer everyone a trigger warning. Some of the stories of abuse are really horrific to hear. So feel free to step away, of course, if you need to. If you have any questions, feel free to put them in the chat. We're going to leave 15 minutes at the end to get to those with our panelists. So without further ado, let's introduce our panelists. I'm going to start with Colleen McCarty. Hi, Colleen.
Hi, Alex.
Could you tell us your name, your title, organization?
Yeah, my name is Colleen McCarty. I am an attorney and I'm the executive director of Oklahoma Appleseed Center for Law and Justice. We are a member of the Appleseed Network. There are 17 other Appleseed centers across the country, and we are the Oklahoma Center. But we get to work on our own state-specific issues. And one of the issues we've been working on since we were founded is criminalized survivorship, which is what we're going to be talking about today, and trying to get Oklahoma to pass a bill that would reduce sentences for domestic violence survivors stuck in the criminal justice system.
Wonderful. Thank you so much for joining us. Mulumba, would you introduce yourself?
Sure. My name is Mulumba Kazigo. With Hudson Link. I'm formerly incarcerated. My experience of incarceration is directly linked to my experience with domestic violence, and in 2020 I used a law similar to HB 1639 to successfully reduce my sentence.
Wonderful. Welcome. Dr. McLeod.
Hi, everyone. My name is David McLeod. I am a professor here at the University of Oklahoma. Have a long background working in this stuff. I started off my journey as a police detective, then became a forensic social worker, and I spent the last 15 or so years specifically researching differential criminal behavior and its impact on people, relationships, and behavioral predictions. So found myself in Oklahoma. We'll talk about that, I'm sure, as we get going, but I'm thankful to be here and thankful to be a part of this project.
Thank you so much. And last but most certainly not least, Monica, who is also the co-author of the Domestic Violence Survivor Justice Act report done between SJP and the Sentencing Project, which will be in the chat, should you like to read it. Monica.
Thank you. Monica Szlekovics, pronoun she, her. I'm the project coordinator for the Survivors Justice Project. The Survivors Justice Project fights for decarceration through the New York Domestic Violence Survivors Justice Act. We are a project of Women in Justice Project and are a collective, which is important to stress, a collective of activists, lawyers, social workers, students, and researchers, many of whom are survivors of domestic violence and long-term incarceration. Thank you.
Wonderful. Well, you know what, Monica, I'm just going to keep you on the mic. For those who might not know who are joining us, even if they themselves are experts in aiding people who are experiencing domestic violence, tell us what a Domestic Violence Survivor Justice Act is.
So I'll speak to what it is in New York. So the DVSJA, which you will hear it referred to as a lot. So in New York, the DVSJA takes a broad view of domestic violence as more than just intimate partner abuse. It includes other family member relationships, and the victim of the offense does not need to be the individual who perpetrated the abuse. The DVSJA allows for relief for survivors convicted of a range of offenses, including felonies, which is unique to New York. It's the first sentencing law of its kind that allowed for relief for people convicted of serious felonies. And so what it does is allows for relief for people convicted of a range of offenses. And what it does is allows judges to sentence survivors to shorter prison terms and in some cases, community-based alternatives to incarceration.
Wonderful. We are definitely trying to get that law passed in a lot of places, and we will talk about that. But also for folks who are joining us, for whom talk of domestic violence is something that they see through a very specific lens that they might see on, say, television. Dr. McLeod, would you just sort of expand on what domestic violence is from an academic standpoint?
Absolutely. And I can talk about this academically, theoretically, but what I want to focus on and make sure that I'm being specific about, we've explored and researched for several years what domestic violence actually is through the eyes of people experiencing it. Right. So in our criminal or legal systems in popular culture, we would assume, or we kind of start to have this propensity to connect domestic violence to being hitting someone, assaulting someone in some way. And while those are components of it, what we found through the research is that domestic violence is more a system of behavioral control. We've had lots of different models that we've used to try to explain it over time and train people. Lots of us have been trained in those, and those can be really helpful in us understanding, but it is more dynamic than saying it's just a cycle. It's a system, and it's in relationships. Things fluctuate and power becomes disproportionate. And when that power becomes disproportionate, it allows for one partner to control the behavior of another partner. A lot of the research language around this gets into things like coercive control, when specific threats or demands are made about the expectations for the daily behaviors of someone. What we found is once those coercive control, we've been able to measure in Oklahoma's women and in incarcerated women in Oklahoma in particular, how those mechanisms of coercive control translate into physical and sexual violence in the relationship. Component two that gets left out a lot of times. And there are other things outside of physical violence that tend to be even more predictive of submission to abusive behavior. Things like fear of separation from children, threats to harm other loved ones. And of course, we see things like financial abuse or threatening and getting a partner involved in a legal situation, making them lose their job. All of those types of behaviors that are there to enforce control of somebody, I would say empirically fall under the definition of domestic violence.
Thank you so much for that. It is a much bigger thing than many people think it to be. And the question that I get asked all the time as the Sentencing Project is aiding in domestic violence survivor Justice Act passages across the country is this really as big of a problem as we're making it out to be? Like, how many people does this actually help? And Colleen, I'm going to throw this to you as somebody who has been fighting for the domestic violence survivor justice law in Oklahoma. Why do we need this law?
Well, it's a really broad question. We work on behalf of a woman named April Wilkins, who is a criminalized survivor here in Oklahoma, serving a life sentence at Mabel Bassett Correctional Center. She was in an abusive relationship with her ex-fiance on again, off again in 1996 through 1998. And ultimately, they got into a life or death altercation. She was handcuffed in his basement. He charged at her. She was able to get his gun and ended his life tragically. But this was after a series of very violent, altercations where she attempted to involve law enforcement and it didn't work out. They filed first-degree premeditated murder charges on her within 24 hours of the crime happening. And she was tried by a jury in 1999 and found guilty. And the only sentencing options were life or life without parole because it was a murder charge. Even the juror that we spoke to for the podcast that we did about her case said, if I had the option, I would have sentenced her to 7 to 10 years, but I didn't because it was mandatory life or life without parole. Because of the excessive sentencing laws here on the books in Oklahoma, many crimes that stem from domestic violence have excessive sentencing ranges leading all the way up to life or life without parole. And ultimately, April is not the only one. We also were curious about this, Alex, because Oklahoma is one of the most traumatized states in the nation, all the way back to childhood. And so, if you wanted to claim that being a victim of child sexual abuse or abuse when you were a child led to a crime that you committed way later in life, we would have a lot of people that would apply for something like DVSJA. So it really depends on how you define this kind of relief. We sent a survey into Maple Bassett last year and heard back from 150 women who would identify themselves as criminalized survivors. However, them identifying themselves doesn't always mean that they will fall under the definition that gets passed in statute. The way we've been describing it is that your crime directly stemmed from your victimization. And there are three main profiles that occurs with. There's a statute here called failure to protect. So when you are in a domestic violence relationship and your partner commits violence against your children, you can be prosecuted for a form of child neglect, which is failing to protect your children from domestic violence. That is a criminalized survivorship type of profile. Another one is when you're in a coercive relationship and the person coerces you to commit a crime. So that could be a drug crime, that could be a theft or property crime. It could even be a white collar crime, depending on the relationship. And then the one that people think of the most frequently is a crime that stems from fighting back. So you are actively in the altercation with the person, you commit an act of violence in self-defense or in fighting back, and you end up getting prosecuted. That could go all the way from just a typical assault and battery charge to all the way up to first-degree murder, like what happened with April. Not all of them are in for any type of first-degree murder crime. Some of them are just shooting with intent to kill. Some of them are, like I said, they are getting charged with domestic violence, assault, and battery. So it's a wide range of underlying criminal behavior that can qualify. And so what really matters how you identify the statutory language that can help. But we would of course like all survivors to come home. That would be the goal, or that they never get prosecuted to begin with, is the ultimate goal. But where we're at right now, there are a ton of people that fall under those three categories that I mentioned. I don't have a good estimate on how many people that is in the state of Oklahoma. We know that 66%, due to Dr. McLeod's research, 66% of women in prison were in a violent relationship within the year before they went to prison. So I don't think all of them would qualify, but a certain big subset of them would.
So as big of a problem as we make it out to be, Mulumba, I want to move to you. And I actually just want to thank you publicly for the way that you've shared your story as a recipient of DVSJA, not just in New York State, but with our friends here in Oklahoma. Can you tell us what it was like when the law passed, what the process was like going through it, and what it was like to actually receive your freedom and have what happened to you recognized by the state?
Okay, so the first question, what it was like when the law was passed. So from what I learned afterwards, and this was after I was released, the law passed in April of 2019. Given where I was receiving limited information, and as a result of that, I didn't learn about the law's passage until January of 2020 through a prison newsletter called Pro Se. So when I first learned about backtracking, I'd known prior to that there was a campaign underway to secure the passage of this law. And I've been in contact with someone working for an organization that was part of the campaign to enable the passage of this law. So I think the last time I spoke to her was probably in 2017. By that time, I knew that there were enough votes in the Assembly and the Senate to get the bill passed, but the difficulty was getting it out of committee. So fast forward to 2020, when I first learned about the passage of this law, I was happy, I was relieved, I was surprised that it happened. But at the same time, I cautioned myself. At that time, I probably served at least 14 years of a 20-year prison sentence. And by that time, I'd also developed a deeper appreciation for just how punitive the system could be. In New York State, the belief is that justice and rehabilitation are best achieved through ever greater forms of punishment. So just as one example, people routinely, I think, written up and given 30 days keep lock for a myriad of, let's say, petty offenses, such as taking an extra 2 slices of bread, or, you hear stories about people being assaulted, in some cases even killed. So having lived under that system for the past 14 years, I said to myself, one other thing to add, I had conversations, I think, prior to 2020 concerning the possibility of having my sentence reduced because, due to the abuse that led to my crime. And people would often tell me, just don't bother. Courts are just not receptive to those kinds of arguments. So when I first learned about this law in 2020, I wasn't terribly hopeful. And I think it explains that probably for at least 2 weeks, I didn't really do anything in terms of actually taking measurable and tangible steps to obtain sentencing relief. I do recall at one point going to the law library and speaking to a law clerk in there, a gentleman named Mr. Brown. He was a paralegal. And I asked him to help me generate a resentencing petition. And he said to me, no, I just don't have the resources to do it. But he did give me a letter to an organization called the Office of the Appellate Defender. Once again, my skepticism led me to not really do anything. I let the letter just sit on my bed for probably about a week or two. But I think probably at least a week after I received this letter, I remember reading it. And the letter basically said, hi, my name is, I forget the name of the attorney. Are you incarcerated? Is your experience of incarceration directly linked to domestic violence? If so, please share your story. And something that letter did prompt me to. So I sat down, generated a written account of what I've been through, and I sent it to her. They sent it to Nassau County Legal Aid Society. In turn, they contacted Kate Mogulescu at the Brooklyn Law School. She came to visit me. At this point, the main issue is backtrack. So back in 2005 and 2006, when I was arrested, me and some of my family members had sat down and talked about the violence that we had suffered at the hands of my father. And so, fortunately for me, there was a lot of documented evidence that could substantiate my claims of abuse. So the challenge now was getting this documentation along with other corroborating testimony, sitting down and generating not only a written account of the abuse that I suffered, but also explaining how this new law could apply to the facts of my case and why this new law qualified me for sentencing relief. And that's what my lawyer was doing pretty much from January up until mid-July when the petition was filed with the courts. I remember sometime around that month, to my everlasting surprise, I received a response from the district attorney in which she supported my arguments. She clearly stated that the abuse that I experienced, the abuse that me and the rest of my siblings had experienced, qualified me for sentencing relief, which was, at that point, that's what we considered the largest obstacle to success in this endeavor. So having overcome that, the challenge now was just sitting down and coming up with a date for a resentencing hearing. We were able to do that, and on Wednesday, August the 26th of 2020, I had my resentencing hearing it was via Zoom, in front of a judge and a representative from the Nassau County District Attorney's Office. And at that hearing, basically, the representative from the prosecutor's office just reiterated the same arguments that we put forth, explaining why I qualified for sentencing relief. Then my term came, I apologized for what had happened, and the judge resentenced me at that point to 5 years in prison plus 5 years of sentencing relief. According to the DVSJA law, since I was convicted of a Class B felony, first-degree manslaughter, my new sentence plus the 5 years of post-release supervision counted as part of the 15 years I had served, meaning I had no post-release supervision. And on that very day, I was released. I'm glad to be out, but at the same time, I'm well aware that there are many men and women just like me, other defendants in prisons, in Oklahoma, in other states, and quite frankly, in other prisons around the world, whose experiences of crime are directly linked to, the problem of domestic violence, but unfortunately, will never receive the kind of sentencing relief that I was afforded by the courts in Nassau County. And
Mulumba, we're seeing what we can do about that.
Yes.
we're all actively seeing what we can do about that. Yeah. But Monica, let me turn to you real quick. It took how many years to pass the DVSJA law in New York State? You all had a tireless fight. You guys were relentless in getting this done. Tell us about it.
So as Mulumba said, the law itself was passed in 2019, but we traced the roots back to legislative hearings that were actually held in Bedford Hills in 1985. And then from there, in 2009. It took a lot of fermenting and a lot of percolation, but then in 2009, the New York Coalition of Women as Prisoners organized and led the DVSJA campaign. And then in 2019, it was finally passed. So it was 10 years of advocacy and a lot of work done by directly impacted women. They were the main leaders in the work, sharing their story, sharing their experiences. And a lot of the work was done with women inside and people who had been released since then, you know, and so it was a collaborative effort, but 10 years of advocacy.
Absolutely amazing. So I want to turn to my friends from Oklahoma. I invited Oklahoma specifically because although domestic violence is present all across the country, it is a scourge all across the country, and survivors are being criminalized all across the country. As of this year, Oklahoma officially has the #1 rate of domestic violence, ranks top 3 for women who are killed by men, and historically has sat at the top of the charts for incarceration of women and people in general. So now that Oklahoma has this high rate, what do you all feel needs to be done in Oklahoma in order to make the Domestic Violence Survivor Justice Act a reality? What do people need to understand that's happening that they might not get?
So a law like the Domestic Violence Survivors Justice Act is not going to fix our domestic violence crisis happening in the state. It's a multi-layered, multi-tiered problem that starts from the first moment someone realizes they're in a situation where they need to call police, all the way to the point when someone is sentenced for a crime, whether it's the offender or the victim. And so we need interventions every single point along that. And it needs to be from everyone, from your church all the way to the sheriff's office. Like, we need it to be robust, and it needs to be a serious intervention. We need awareness. We need it happening in classrooms. We need it happening relationship counseling and teaching people about healthy relationships, and a cultural change is really what we need to address the problem. But as I say about the DVSJA law, it's really the least we can do, because if we're not going to impact the law enforcement response, if we're not going to impact the prosecutorial response, then we must at least, for the very least we can do, is reduce the excessive sentencing that survivors are facing across the state when they ultimately do get prosecuted, which happens routinely. I still hear about it every day, someone going to jail covered in blood as a victim of domestic violence and being hosed off before they get their booking picture. So it is not something that's not happening, and it's not something that is just a one-off. It is happening routinely as part of our criminal justice and policing system in the state. I think what the problem is that in order to fix this problem, the folks who are doing the problem have to acknowledge that it is a problem, and they have to commit themselves to fixing it going forward. And then they have to be willing to acknowledge all of the times it's happened in the past. And then there is a fear that that amount of work that will require is insurmountable. And I don't disagree, but that doesn't mean we don't do it. I mean, that's frankly how I feel about it. It's the system of justice. The system of justice is to get it right. And it's to get it right as many times as we need to. And if we didn't get it right, then we go back and we fix it. That's what America does. And so I think, as overwhelming as the number of cases could end up being, it's the commitment that we make from the government to its people. We are governed by the people. And it's just not acceptable to me that we're going to say, yeah, sure, we'll fix it going forward, but not going backwards.
Absolutely.
I'm just not okay with that. And we won't ever be okay with that. There must be a retroactive component. That is the whole point.
Absolutely. Dr. McLeod, there was a question in the chat which segues perfectly into what I was going to ask. Why is Oklahoma #1? I mean, how does a state get to this point?
Yeah, that's a great question. And to address that, I think we need to look no further than the data. The idea that Oklahoma over-incarcerates and is a world leader in the incarceration of women, for example, cannot statistically be separated from being one of the most traumatic states in the U.S. children. It cannot be separated from poverty and the level of poverty and the feminization of poverty in the state of Oklahoma. There are all kinds of constructs that to support what Colleen was saying. One, we have to come at the problem from every single perspective. So the data says that there is an overwhelming marginalization of children in this state. We have to accept that as true. We need a social shift to move into some of these conversations that are really difficult and people want to avoid. I've spent my entire adult life to reduce violence directed at women and children in a lot of different ways. And I found myself several years back during the time of the beginning of the Me Too movement, needing to stand in front of my classrooms and say something that's incredibly uncomfortable. And that is that with all of my straight white manness and all of the work that I have done and the commitment that I have in my life to reducing this violence, I still benefit from feminine fear in my community. And many of us on this webinar do as well. That doesn't make it okay. It doesn't mean we asked for it. We got to remove that idea of judgment for the men in our state. Oklahoma, that's to speak to something else that Colleen mentions there. We must accept some responsibility. Even if you don't go around hitting people, that does not mean that we don't accept responsibility, that we can do better, we can be better, and it doesn't take being perfect to be better. So the data is overwhelming and it doesn't matter from which place we look at it. That's number one. All of these things are autonomy, economics, racism, and the systemic nature by which things like domestic violence are codified in our systems. So I'll say one other thing here that I think is connected to the incarceration of survivors. In Oklahoma, it is not enough that women make less money for the same job, right? It's not enough that we have all these complexities that pile on top of there, racism. We got all this stuff. There are other laws that we are struggling to fight against as well. Right? But it is that in this state, if a woman is uncomfortable or doesn't like being abused, we will incarcerate her for fighting back. That is a mindset that we must accept and acknowledge is toxic and barbaric. We have codified, we have developed and solidified and reinforced that women's survival in our community requires subjugation and an acceptance of that. And so those of us who want to stand proud as Oklahomans, they want to say this is the Oklahoma standard and the Oklahoma way, and we're good people. It's time for us to actually be good people. It's time for us to recognize some of these things that people don't talk about. So that notion of we must talk about this and get it out there, no matter how uncomfortable it is.
Could you also just share with us some of the data specifics on that? Because I read your research, but a lot of people here might not have. Actually looking at offense types, and that most of the women within a year of the major abuse ended up incarcerated.
So what we found in research with and partnered with incarcerated women here in Oklahoma is that upwards of about 65% of the women who we have locked up were in an abusive relationship at the time of being arrested for the controlling offense that sent them to prison, right? So that's one thing that we have to acknowledge as real and true. Now, when we dug deeper with these women to understand more about that experience, we found several things that were very telling and important for us as advocates to move forward with. Violent crimes, drug offenses, financial crimes. We were able to all of these things to measure experiences of domestic violence and coercive control. So if someone has specific threats or demands that they make about your health, of alcohol or drugs that you use or don't use, the likelihood that you could be arrested for a drug-related crime begins to escalate. So it's telling. We can see it in the layers of the data, for example, that we know that these things are connected. Another thing to mention, we found in the data specifically that there's this process. Women don't just wake up one day and they're incarcerated in Oklahoma. They wake up one day and they're in an abusive relationship. This starts with very young, and that these women are in abusive homes of origin. We see the risk was 13, 14, 15. Now their peer group starts aging into behaviors that are them at higher risk in their homes. And we see them move from those young youth-related relationships into sick, often fleeing, or all the effects of trauma. The people on this call understand how trauma works, right? So these women are fleeing abuse literally their entire lives, and then we lock them up. And we do so in this state at a way that's not just economically sustainable. When we look at how many women have children and all those kinds of fun pieces of data, and the likelihood of being arrested and incarcerated if your parents were, we see that we've swung really, really strongly into the of intergenerational incarceration that I think is specifically and tangibly linked to the of women in our state.
Very disturbing findings. Colleen, I'm so sorry. I think I cut you off. You were about to say something.
I was going to jump in and be impromptu for a second, but like when you were talking, Dr. McLeod, about how prevalent it is, I was just going to say we shouldn't shy away from policy change because there is something prevalent. We should lean into policy change because something is prevalent. Don't we want our policies to impact a lot of folks? So we want a lot of people to be benefiting from the law changes and the policy changes that we are making. I think that's just something that we were kind of hovering around, but the 66% number, I think can scare off some lawmakers because it's like, oh no, the courts are going to get flooded with a bunch of applications and people are going to be trying to get shorter sentences. And it's like, yes, they are.
Mission accomplished. Well, you know what, Monica and Mulumba, let's talk about that, because DVSJA exists in your state. Did everything fall apart? Is the sky fallen in New York State because you're helping domestic violence survivors? Are things in flames? What happened?
I'll try and take us out. No, the answer is no. I mean, I think that the court system is still functioning. What's happening is that people who have legitimate claims that their crimes are somehow linked to their experience of domestic violence are sitting down and asking the courts to take a second look at their cases, and the courts are doing just that. So yeah, I think it could happen in Oklahoma and everywhere else without having a meltdown.
Absolutely. Monica, 53 people have been released in New York State thus far. How are they doing?
So the ones that we're in the contact with, it kind of runs the gamut. Everyone experiences the difficulties of reentry, especially after long-term incarceration. These individuals are no different. You still have a record, so you still face the challenges of finding housing, finding employment, so all of them challenges are still intact. And then you have the challenge of, trying to navigate, parole if you're still on parole, because not everyone was released from parole. Some people still have supervision afterwards. And so there's still many challenges that people face, that is to say, but overall, people return and, they try to build relationships to their children or stay connected to their children in the way that they were inside, and they continue them relationships. And they thrive in many different ways, but there's still many challenges.
Or you do fabulous things like our friend Mulumba here, where he's reaching out to people in other states, you know, and keeping them hopeful. Mulumba, tell us a little bit about the relationships that you've developed actually with Oklahoma specifically, and why you literally reached out to news channels in Oklahoma to correct them on the fact that they were saying that men don't get abused and won't get this relief.
Yeah, I mean, I'll start that by saying, yeah, I mean, when I first, one reason why I was really initially reluctant to do anything when I first learned about this law was because of my gender. I mean, to me and to this day, I still have this image of, of who constitutes a domestic violence victim to be a woman. I think that explains why I initially really didn't do anything. What was the question? I'm sorry. Can you repeat the question? I'm sorry.
No, I was saying, you reached out to the news in Oklahoma
Oh,
that you felt so passionate about writing to other people and keeping them hopeful.
I strongly believe that other domestic violence survivors in prison should receive the kind of relief that I was granted by the courts in Nassau County. I mean, I can't begin to describe just how relieved and happy that I felt. And I think that, at first I was numb, but as the weeks and months went by, I developed a much deeper appreciation for what had happened, just how unprecedented and profound that it was. The notion that someone like myself, someone convicted of one of the worst crimes in this state, given not just that I committed a crime, but I think just as more importantly, the level of premeditation that I engaged in, the notion that someone like myself would be granted sentencing relief, would have my sentence reduced due to the abuse that I suffered, was something that I really thought was just almost improbable. So when it happened, I was just really, really surprised. But at the same time, I think a couple of weeks after my release, I learned about someone else who deserved sentencing relief, someone called Colleen, but hadn't. And so I think eventually the appellate court did reduce her sentence, but I think it's her case. And also just knowing that when I learned about what had happened in Oklahoma in March, when I learned that retroactivity had been removed, I was disgusted and outraged. I really thought that. I found it especially awful that these women, Maisel Bassett, sat down and went through the painful ordeal of generating written accounts of their experiences, shared these experiences with the legislators, in the hope that, and then, if the legislature in Oklahoma had not passed this law, I wouldn't have responded, but it did. And one of the main reasons they did was because they learned about what had been going on. HB 1639 in many ways was a direct response to these stories. And then to say that, well, okay, yeah, you provided us with these stories. Okay, we're going to pass the law, but you're not going to be included. There's something to me especially cynical and cruel about something like that. And that's why I reached out. I didn't think that sharing my story and having that interview would really do much to change the minds of people in Oklahoma. But the satisfaction comes from knowing that at least I tried. And so, yeah, I'm glad to, be here, involve myself in this, correspond with April, and involve myself in other criminal justice reform efforts in New York State, such as the Second Look Act and other bills that I'm working with others to get passed through the legislature.
Well, you were very impactful, Mulumba. I'd have to disagree with that because literally people would yell at Colleen and I, well, men are victims of abuse too. We were like, yes, we know. And they're like, well, they're not going to get help by DVSJ. And I was like, please speak to my friend Mulumba. And you did every single time. And I thought it was very important that people understand that abuse is not specific to any identity or gender.
Yeah.
And this relief crosses the board.
Yeah. No, it happens to both men and women. What me and my brother-in-law, my brother Gabriel, my brother Joseph went through childhood was just awful, absolutely awful. What I did was wrong, what I did to my father was wrong, but I'm just really glad that the courts responded the way that they did when I applied for sentencing relief. So
family violence, spousal violence, it's all there. Yes, Monica, please.
Yeah, I just want to chime in and point out that Mulumba was actually the first DVSJ recipient in New York to get relief under retroactivity. And, and to date, there are 4 men and 1 non-binary person that have gotten relief, but it still is a long way to go to getting courts to recognize that DV is an issue for men. And there's a lot of, issues with that, but I just wanted to chime in and say that.
Thank you.
I think that was one of the things that was so incredibly powerful when I first met you, Mulumba. And the way that you've lived your life and the way you've helped people since is just absolutely phenomenal. So let's talk about what we need to do in our last 5 minutes here, because clearly we have a massive problem. Colleen, Dr. McLeod, what do we need to do to create a truly trauma-informed system? How do we fix this? Colleen, you said we need intervention all the way through, but like, what does a law actually have to say to get at the heart of abuse and how it takes people to prison?
Well, I think there needs to be a lot of changes to make the law trauma informed, not just in sentencing, right? Like, we're still doing strip searches when women get to prison. These are women who are oftentimes victims of sexual assault. I mean, like, that is re-traumatizing. There should really be like a trauma informed overlay across all of the criminal justice laws that we have on the books. Here in Oklahoma, we haven't done any of that work yet. I mean, there are, of course, in the civil space, in the family law space, is a lot better as far as inputting more trauma-informed statutes. But on the criminal side, it's really still about how harsh can we be, how punitive can we be, and how cruel can we be. That has been the point of, and the animus behind a lot of the lawmaking that has happened on the criminal side. And so I think in order to get to a place where we're recognizing that trauma has an impact on behavior, it's not an excuse for behavior. That is part of what I think the more conservative lawmakers and more conservative law enforcement voices are raising, is this fear that we're trying to excuse all criminality or all criminal behavior by talking about the fact that the person has been traumatized. And that is not where we're coming from at all, really. It's saying that the trauma is an explanation for and gives context for the criminal behavior, and it should be taken into account when you are considering punishment, right? Because if someone is out here just visibly a serial killer killing lots of people with lots of witnesses and has, no excuse for it, that's morally very different than someone who has been hurt reacting from a place of trauma and committing a crime. Those sentences should be considered differently. There's a whole process in the law for mitigation, but only comes into context under certain types of crimes. That doesn't make sense. You get an entire mitigation procedure if you are up for the death penalty. So for the worst types of crimes in Oklahoma, in Oklahoma's history that we could ever consider, that person gets an entire procedure dedicated to mitigation so that the jury can hear all of the reasons why they shouldn't be put to death. But any crime lesser than that, we aren't doing any mitigation for that. That doesn't make any sense to me. That's completely backwards. Every person who's getting prosecuted for a crime should have the opportunity for mitigation, and they should be able to enter the evidence of their trauma or the reason that they did the thing. I mean, as a human being, you want to understand, it's a very basic need to understand why something happened, whether it comes from a place of wanting to prevent it from happening in the future, or whether it just comes from a place of like morbid curiosity. The criminal system isn't built for anybody to understand why something happened, because the whole process is about protecting the defendant from explaining what happened, right? And that's for good reason. But when we get to the sentencing phase and we're going to say you are guilty of the crime, you did it, like factually, legally, now you're guilty. At that point, we should allow ourselves the ability to say why, and that should factor into the crime. That should factor into the punishment.
Absolutely. In our last minute here, panelists, feel free to jump in. Any last words before we take questions? All right, well, let's get into the questions because we have a lot of them. Mm-hmm. Monica, this is for you. Does this policy include the immediate release or reduction of sentencing for people currently incarcerated?
Yes, so the law is retroactive in New York State. It's retroactive for people who were sentenced before the law's enactment in 2019, and for people who are now entering the system and have were convicted after 2019, they no longer can apply for retroactivity. So therein lies a problem with New York sentencing law at this point, where it's one bite of the apple, and if you don't take it at the front end, you won't get it at the back end if you're sentenced and prosecuted now.
And that also plays into a question where people said, does a DVSJA apply pre-sentencing or post-conviction or both? For the law written in Oklahoma, it's both. For New York State, it is also both. And I would encourage anybody who is promoting a DVSJA law in their state to do both. Colleen, I think this is for you because it's a legal question. Can you explain how the DVSJA is different from habeas relief for DV survivors? They're specifically from California, but anything you can offer.
The California legislature passed a bill, I think probably 10 years ago, that allowed women or anyone, a survivor in prison, to essentially get a special type of parole if they were a survivor of domestic violence. That was solely a post-conviction procedure. It didn't really apply to anyone on the front end of mitigation or sentencing going through the process like we've just been talking about. The Oklahoma law is a lot more like the New York law. So it has a procedure for sentencing mitigation for anyone getting prosecuted from that date of enactment going forward. So if I get arrested after the law goes into effect and I have been an abuse victim, I can enter evidence at a mitigation hearing of the abuse and if I prove that I was abused, I'd be entered into a lower sentencing range depending on the range of the underlying crimes sentence. So that's a little confusing, but if my underlying range is 0 to 8, normally, and I can prove the abuse, then I'm entered into a lower range, 0 to 4, I think is what we originally wrote in there. And then it goes up from there. And then it also has a resentencing provision for folks who are currently incarcerated. They do have to apply. So just like what happened in New York, it's not going to be a mass resentencing. The person has to prove that they were the victim of abuse and that the abuse substantially related to the crime for which they're serving time. If the court finds that that is true by a preponderance of the evidence, which is about half, more likely than not, then they are again entered into the lower sentencing ranges that are the same as from the front end of the bill. The lower sentencing ranges, if they've already served that amount of time, they get out on time served. If they haven't served that amount of time, then the sentence is just amended and they serve the balance.
One of the very important questions that I see being asked is, are you also looking at women who are convicted of other crimes like drugs, conspiracy, who are survivors of domestic violence, who assist their abuser, who do not flip on their abuser, and then end up getting long sentences? The long and the short answer, and I also would encourage you again to look at our DVSJA report, because we learned many lessons from New York State on this with the broad range of offense types that were eligible. But Monica, Colleen, do y'all want to jump in on this one?
I'll just say quickly that, of course, in Oklahoma, we want to provide relief for as many survivors as possible. That's always our North Star. But politically, there's only so much that we can do. The first thing the legislators wanted to do this year when we were advocating for this law was to start restricting by crime types and start restricting by types of behavior. So that is one of the fertile grounds for negotiation, unfortunately. I am advocating for, as long as you can prove the substantial relationship between the abuse and the criminal behavior, that you should be someone who qualifies, regardless of the underlying crime. Regardless of the underlying crime. But that's sort of one of those things that's going to be tough to get through our legislature.
Monica, would you want to chime in on why New York? You all were very expansive in your language, very specifically. Do you want to comment? I think one of the things that you were very specific about when I talked with you all was about drug offenses, and making sure that a lot of those types of offenses got included, even though it was not an immediate threat DV situation.
Well, we all know histories or trauma contribute to why people are incarcerated on the onset anyway. And so really what it is for New York is getting judges and prosecutors and the types to understand how them histories of trauma it's a continuation of, what leads to incarceration. And there is this point where it crosses, and some courts actually have conceded that and resentenced people, and other courts have said they just don't understand the correlation between the two, and that trauma is just not a moment in time. It doesn't erase itself. You think of trauma of incarceration, so it starts at point of arrest. So you have the trauma of the incarceration. So, and helping people understand that. You'd be amazed at how many people do not understand DV, the basics of DV, where a lot of judges and prosecutors have no conception of it whatsoever in 2023. And then you're wondering, like, where are we at? Like, why do people not understand the basics?
Absolutely. And Doctor, this one's directed to you because you are also former law enforcement. So sorry if this one's a little more spicy, but I'm interested in intervention and prevention held by community outside of law enforcement. Would interventions carried by sheriff police be more harmful than helpful? Have there been any past experiences at large where a law enforcement has been helpful?
Complex question. I think that we have let me answer it in a couple of different spaces. One, I think system-wise, criminal justice system, including law enforcement and the courts, we need to call out an elephant in the room. And that elephant in the room is that the data collected literally from the FBI, says that over half of law enforcement officers surveyed exhibited behaviors in their own home that would qualify as domestic violence. That, I believe, is connected to something we need to be honest and talk about. The culture, if we're looking to change a system and the people that interact in the system, we have to accept that many of us in the system are having to deal with folks who are in a state of fear that their own behavior is not acceptable either. And human beings will externalize and justify, and we create all kinds of different ways so that we don't have to feel the guilt and shame, and we can show how we are different than other people. So part of this solution and the wraparound way to solve the problem is connected to understanding more about how human beings function and work both individually and collectively in systems. That, I believe, and I want to get into this little piece too. Understanding the neuroscience of trauma is important. To be trauma informed is about lots of different things. And one of those components is that if anybody out there that doesn't know this, it's worth regurgitating if you've already heard it. The experience of trauma and abusive relationships create a actual physical body. And kind of abuse it is. It could be being hit in the face or living in fear of being hit in the face. It will ignite the same brain chemistry, release the same brain chemicals, and connect the same synapses of the brain together, and it will produce an actual biological injury that then has the capacity to influence our behavior literally on a subconscious level. That is just true. It's not like we're debating it. It's true. It's measurable. Every single one of us here in this room, this digital room, and it impacts every person that's incarcerated. Now, if we know that to be true, we also have to accept that sentencing and how we think about these things has great complexity. So when my colleagues here on the screen talk about the differential ways in our scenarios so that we can try to be as equitable as possible, those are going to be important parts of moving the systems forward. The systems as they exist right now, you can take a look at your system. I look at these nationally and by different political zones or regions of politics. They don't work that well. And so leaving the full duty of solving violence epidemic in the hands of our current criminal justice system alone, we've already seen that it doesn't work effectively or efficiently, not to mention altruistically or respecting of human dignity. We've seen it just doesn't work. And so I believe that our systems are part of a solution, but we have far over-relied on a system that in many ways functions as it was intended to function. Somebody in the chat mentioned how rich people get to have these mitigation type systems and differential experiences in the court systems. Turn on any TV you've got right now, and you see the one standard, others of us are held to different standards. We know that it can be done, but it's time that it be done for everybody that experiences the court system, not just those who have incredible fame and financial resources. You can get me started now.
Yeah. There are a couple of questions specifically. How can the average citizen help advance efforts to help DV survivors? Now, I see from the attendance list that a lot of my friends who help DV survivors in Oklahoma are here. Please drop links in the chat. Monica, please drop links for New York State in the chat on how folks can get involved. Visit us at thesentencingproject.org. You can sign up for our newsletters. You can read our reports. We are working with a lot of our friends here on the screen, and there is more than enough for everyone to do. So we also have a question here, Colleen, I'll direct this towards you. Can you share resources, support groups, organizations in Oklahoma for male victims and survivors? And maybe the good doctor has some recommendations as well that could be put into the chat. And can I just say, I'm so thrilled that this conversation is coming up and that people are looking for help and support. Do
you want me to share cases? Put it into the chat.
Please.
Oh,
share out loud and put it in the chat.
Okay, DVS in Tulsa and YWCA Oklahoma City and Palomar all are gender neutral support for any survivors of domestic violence. And the Survivor Resource Network in Shawnee and in Violence Oklahoma service the whole state as a coalition, so they can find you somebody if you're not in those areas.
Wonderful, thank you.
Absolutely.
In case,
we'll throw this out there just to say it explicitly in case there's any confusion. Violence comes in such a complex, three-dimensional kind of, it is incredibly diverse, as are relationships. So there are all kinds of ways to express violence, to experience and survive violence, and there are all kinds of diversities of relationships. And so oftentimes I and others, when we get in these types of conversations, we'll find ourselves kind of getting down into the male, female, typical dynamic. And when we do that, we miss of experiences that are important to the conversation. So I echo many friends of ours, DVS, Palomar, many others have resources and understand and really approach it from that way as well. So please do reach out to them.
We have time for one more question before we have to draw to a close. And I think what I will do is that in cases where both the abused victim and the abusive perpetrator were convicted for domestic violence, does the data reveal any difference in the sentences that they receive? So in cases where the survivor goes to prison and the perpetrator goes to prison, and I see Colleen smiling and I know exactly the case she's thinking about right now. The short answer is yes, but Colleen, do you want to give some color to this one? Or Monica or Mulumba?
There's a specific case that Alex is thinking of here in Oklahoma. We do see disparate sentencing in cases where both offenders are being charged. This is specific to failure to protect type cases. We've got a famous case here in Oklahoma where the man who left his leg on a sleeping newborn baby and the baby passed away was charged with child neglect, and his partner, who was not in the room, a woman, was charged with child neglect, and he got a 10-year sentence and she got a 20-year sentence, even though she was not the person that hurt the child, and it was her child as well, and she's still in prison today. A lot of times these cases where you're talking about with both people getting charged are stemming from some type of child abuse or child neglect. I don't often see cases where it's the same type of violent incident and both people are getting charged and put through the criminal justice system. Oftentimes, if it's earlier in the cycle of violence, it is the male in heterosexual relationships, it's the male getting charged with the lower level domestic violence charges, assault and battery, those kinds of things. And then as the relationship progresses and the violence gets more extreme and the woman starts fighting back, it is the woman getting the heavier charges later on in the relationship because the violence has escalated. Those are the patterns that I most likely see. So and of course, the sentencing would bear out that the man's getting the shorter sentence because it's the less serious crime, and the woman's getting the more longer sentence because it's the more serious crime.
Well, I think we've passed on quite a bit of information here. Please feel free to reach out to us at the Sentencing Project since we're not able to get to every question. I thank you all for participating in a very important conversation during Domestic Violence Survivor Justice Month. I want to thank each and every one of the panelists. I'm sure you all see why I adore them all personally so much and the work that they do. Thank you all so much for the work that you are doing every day, but very much for participating in our webinar today.
Thank you.
Okay.
Bye, y'all.